Important developments in the Gyanvapi Mosque case, both from the Supreme Court of India as well as from the Varanasi District Court, where all of this began. First, at the Supreme Court, the Apex Court, a bench headed by Justice D.Y. Chandrachud, has agreed to hear the pleas filed by the Masjid Committee from the mosque in Varanasi, which has challenged the recent orders by Varanasi District Court, which have created this controversy. Now, the Apex Court has agreed to hear the challenges filed by the Mosque Committee. It's going to look at their claims that this whole case in the Varanasi District Court is not maintainable because of the 1991 Places of Worship Act, and it's going to conduct its next hearing on 19th May. Now, in the meanwhile, though, it is said it is not interfering with the orders of the Varanasi District Court, including an order allowing for a video survey of the mosque, as well as an order passed on 16th May, where it ordered the sealing of part of the mosque where an alleged shivling was found during the course of this survey which was being conducted there. At the same time, the Apex Court bench has said that these orders passed by the Varanasi Court cannot be allowed to restrict the entry of Muslims into the masjid to offer prayers, and therefore it has managed to balance the interests, while it will, of course, now hear the legal issues going forward. In the meanwhile, the Varanasi District Court on Tuesday, 17th May, has granted the commissioners who have been sent to conduct this video survey more time to be able to submit their report to the court about what they found, and it has also sacked one of the commissioners who had been sent because he leaked information about the survey to the media. Now, that's obviously what's happened in the court on Tuesday, 17th May. A little bit of background, obviously, is that in 2021, a plea was filed in the Varanasi District Court by a bunch of Hindu devotees who were requesting permission to be able to pray and offer, their prayers to Hindu deities in a particular section of this Gyanvapi Mosque in Varanasi, which they argue was originally a Hindu temple, which was then destroyed and converted into a mosque. They say that parts of the original temple are still there, and we want to have the ability to offer prayers at those areas. Currently, this is actually allowed already once in a year. They want this to be allowed throughout the year. So that is the case which is there before the Varanasi court. The court ordered the conduction of video surveys of the mosque to be able to get a full picture of what is there and what is not there, which was being contested by the Masjid Committee, which is why it's now arrived at the Supreme Court. Because this order was passed in April, it was reiterated on the 12th of May. The Masjid Committee approached the Allahabad High Court challenging this, saying that there should be no ability to conduct a video survey. The Allahabad High Court refused to pass a stay, and as a result, now the matter has ended up in the Supreme Court as well. Now, why is it that the Masjid Committee has contested all of this? What they are saying is that, look, there is the 1991 Places of Worship Act, which was passed at the height of tensions over the Ram Janmabhoomi Babri Masjid dispute. And at that time, the Parliament had passed a law which said that, look, leaving aside the Babri Masjid Ayodhya dispute, at this point of time, any place of worship which has been in existence in India since before 15th August 1947 will remain exactly the same it was. There can be no change in its status. There can be no case filed to take away ownership or possession of that from one community to another. Unless, of course, there was a pre-existing case prior to 15th August 1947. But otherwise, no change of status. A place of worship cannot be affected, cannot be changed. So the Masjid Committee says that this whole plea and this request to allow prayers is actually asking for a change of status. They say that Varanasi Court's order allowing the videographic survey, etc. to go on is not possible because the court cannot possibly grant any such relief, and therefore there should be no survey being conducted at all. They've also now filed a challenge against this order about the shivling which has allegedly been found, because they pointed out that this was not based on a report by the commissioners that the court ordered the sealing of the area, but instead merely on an application by one of the lawyers for those Hindu devotees who approached the Varanasi court. Now, all of this is what's being argued by them. They're going to take this up again on 19th May. The court is going to have to look at whether or not whether the Varanasi court could actually pass the orders it did. As regards this whole issue of the possibility of finding a shivling, the court will be looking at the order, at the report filed by the commissioners. They'll be looking at information provided by the Uttar Pradesh government as well. And of course, the contesting arguments by the Masjid Committee, who say that, look, this is not a shivling, it's just part of a fountain which is now being made into this issue to create a problem. So stay tuned to the Quint for all those further updates.